I have your bio up here on the website, and I just what a lot of experience in like three paragraphs. I'm impressed by sort of like your journey. Sometimes I do continuing education credits for the field that I'm in, and I noticed you do the same. And so that sort of positions you really have to know what's going on in the client's mind or the client situation, and yet the new things on with the people in your field. So does that polarity sort of help you get a clearer picture, or does it constantly keep you investigating what's going on both sides of the fence there?
Yeah, I think that anytime you're teaching a group of people, especially when they're professionals in your field, you have to have a really firm grasp on what you're teaching. And I think preparing to teach and then actually doing it, actually presenting at something like a continuing legal education event, I think is it's a great way to kind of solidify your knowledge base and to maybe even to bounce ideas off of other people and things like that. So yeah, I get a lot of benefit out of it, and I've always enjoyed doing it.
No, it makes sense. It goes back to what I learned a long time ago, but never really clicked. To have command of the knowledge to explain it like on a fourth grade level, and
Right.
then as soon as that first question comes, get into the minutia and the justifications and all that. So I think I just find that fascinating. I didn't see it the first time I was reading over this, and I was like, wow, yeah, I I sort of get that vibe. The other one is that you started out in journalism, so your search for the truth started early. Does any of that inquisitive nature or organizational curiosity translate in what you do in the field of workers' compensation?
Yeah, 100%. I think that to be a good journalist, you have to be really curious, right? You uncover a fact and it leads you to the next fact and so on and so forth. And I think in many ways, there's a lot of things that come together to make a good attorney, but one of them is the same thing. It's that desire to kind of uncover the truth, to constantly be searching for the next fact that's going to help out your client. So certainly just being curious and inquisitive, I think there's a lot of crossover there between the two. And then, sometimes people don't understand that so much of what you do as an attorney is writing.
Right?
People have this picture in their mind of you standing in a courtroom, when in fact 98% of the time you're sitting in front of your computer typing, writing. And so all of my experience, with an English degree, with the journalism degree, in terms of writing, I think has benefited me a lot in the legal field.
It seems like it would help right from the jump, like right from the discovery call um, on through filing whatever you have to file. Yeah, you're right. I remember as a child watching a lot of Perry Mason with my grandmother, and he had he had people doing everything, and he just had to present it. And yeah, it gives at least they present him in a positive way, so that's one good
Right.
thing. So that's good. So as you talk about workers' comp, and quite a segue, right? But it's something that the reason why I asked about the being on both sides of an issue or both sides of a situation is that when you're on the side of being injured at work, there's a lot of psychological things that maybe we don't see or study before they even pick up the phone or go online to see if they need some help. So, you know, I just want to ask some questions from that point of view today. Like, the first one is I'm sure that how severe or does it have to be a one-time emergency event? You know, like I stepped off a curb and on my way to work and twisted my ankle or a forklift hit me or something that is like an actual event versus something that's ongoing. My elbow's finally going out because of all the repetitive stress. So is there, someone that got hurt at work, but they're not sure it's worth filing a claim? Do you have any advice or benchmarks? And I know that's not one size fits all, but could you just give it like a lay of the land of definite, triggers of if they have a case?
Sure. So I think, perhaps a good way to envision it is certainly if what happens to you requires any medical care. That's should be a definite sign for people that, if what happened at work is leading me to seek medical care, that should be a signal to you that, I need to, or I should at least consider pursuing a workers' compensation case. I think one of the things that's really difficult for people is, I think by the time we're adults, we have a tendency we have aches and pains, right? And we have a tendency, even if something happens at work and, oh, I've got an ache or a pain in my back, to say, well, I'm sure it'll get better. Let's just give it a few days. Let's give it a few weeks. And those ones are the ones that are a little bit more difficult. I would never advocate for somebody, anytime you feel a twinge of pain, to rush to the ER, but you need to, kind of listen to your body and err on the side of, at the very least, documenting, what happens to you, right? So even if something is relatively minor, completing an injury report with your employer, at least reporting it, to your employer, and again, preferably in writing, so there's documentation. Even if you do plan on waiting, to pursue medical care, then at the very least, we have that initial documentation, right? So as you kind of touched upon already there, a workers' compensation claim does not have to be based on, an acute incident. It can be something that comes from repetitive activity.
You were saying about the repetitive activity. So it's not just one time event. It can accumulate over time.
Yeah, absolutely. So, I'll say that those can be more difficult cases, right? When you do have kind of the classic example of worker picks up box and injures back, or is in a motor vehicle accident, or steps off a curb and breaks their ankle. Those cases are often easier, to establish, at least at the outset. So something like repetitive activity, repetitive trauma, years and years of kind of the accumulation of things over time, that can certainly be the basis of a workers' compensation claim. Might be a little bit harder to establish. And again, so much of it, and I'll repeat it all the time, is about good documentation, right? It's about discussing with a medical provider, hey, I think this is related to my work activity. That ends up in the medical note. It ends up with the doctor exploring that. And all of that documentation becomes very helpful, on down the road when we are trying to establish a claim.
Okay. Just from a logistical perspective, now with Social Security disability, I've learned that primarily your firm handles after the denial phase. And there's a variety of reasons for that. The younger ones, it's usually picked up earlier in the school system. Some types of disability, the applicant has to be the applicant and not representation. And so you guys are getting on after someone has taken the first steps, it's been denied, and now you're coming in. Now with workers' comp, if I understand correctly, that's why I'm asking the question. Earlier the better. Like you will help file everything, or is it sort of the, cleanup phase of after something's been denied?
Yeah, we have a lot of clients who, for better or worse, are repeat clients. They tend to get hurt a lot. They're working in very physical industries, whether it's construction or law enforcement, something like that, where, again, unfortunately, they're getting injured repetitively. And what they tend to learn over time is, as soon as something happens, of course they're seeking medical care, but aside that, they're calling us to get us involved right from the beginning. We can help with filing the initial claim application and everything right from the start. There's this idea that, you have a good way to think of it as you have a cucumber, right, that gets pickled and turned into a pickle. And you can't turn a pickle back into a cucumber. And it's really the same thing here, that unfortunately we do have people come to us. They think they can handle the claim on their own. And sometimes that works out. But what we see fairly frequently is somebody come to us and we see, well, kind of the damage is already done here. We might be past an appeals window on something that we could have prevailed on if we had been involved earlier in the case. So, I definitely think that the earlier you can involve an attorney, it's almost always going, to give you significant benefit. And I think something that's really important that people need to know is, especially with larger employers, but even mid to small size employers, they almost all have legal representation in these workers' compensation claims. So you, as an individual, you're from the outset going up against, an employer, a large entity frequently, that again already has legal representation assisting them with the claim. So I think in almost every case it makes sense to get an attorney involved as quickly as possible, so you can kind of level that playing field.
especially since you mentioned documentation being key, perhaps, saying the right or wrong thing, not finding out things early enough, and then the overlay, I guess there's some filing requirements. Could you touch on those two aspects?
Yeah, absolutely. So documentation is so key early on in the claim. Sometimes people think they get hurt at work and I just need to, tell my boss and that's sufficient. They'll file the workers' compensation claim. And the truth on the ground is that often is not the case. Sometimes an employer will assist an injured worker in filing a claim, especially with larger employers who kind of have an infrastructure in place to handle those types of things. But oftentimes they say, "Oh, I'm sorry to hear that you were injured. Let me know how you're doing," and that's it, right? So it really, as an injured worker, you need to think of it as your responsibility to make sure that your workers' compensation claim gets filed. And again, you can, some people do that on their own. I don't mean to suggest that it's impossible, but involving an attorney is going to help with that whole process of getting the claim filed. So there's a document in the Ohio workers compensation system called the first report of injury, or the FROI, and that is really the key document that needs filed to start the process of the claim application, to start the process of hopefully the claim getting approved, and thereafter, it being in place for you to utilize for medical care or for, pay for your time off work. But, we could spend hours talking about all of the deadlines and timelines involved in these cases. All along the way, there are these deadlines and time periods that you have to do certain things. Generally speaking, you have a year from the time you are injured to file that first report of injury. That's one of the most basic things to understand. But other than that, all along the way, there's going to be BWC orders, industrial commission orders, all sorts of things that come out that you have much smaller windows of time, 14 days, for instance, 10 days to appeal or to take your actions. That's another benefit, of having an attorney involved, is we know all those timelines. Our staff knows all those timelines. We have all this infrastructure in place here to make sure that nothing slips through the cracks, to make sure that all those appeals get timely filed.
No, that makes sense. Now, you'd mentioned your boss in this scenario. There's some things that sort of trip people up about filing. That will this ruin my relationship with my boss? I'm afraid if I file a claim, my employer will get mad or I'll get fired. Does that happen? And do they have any rights that you help protect?
Yeah, so I think in my experience, in terms of the retaliation and things like that, I see it a little more frequently with small businesses, maybe that don't have a large HR infrastructure, maybe is the best way to put it. And I mean to distinguish that from most large employers with professionals and maybe legal departments. Now, I think they understand that workers' compensation injuries are going to occur, and they know that the best thing for them to do is just to accept that and to work, between the employer and the injured worker to try to help them recover from the injury. But certainly we do see situations where a boss or an employer takes it personally. Again, I tend to see it most in kind of small business situations where some a workers' compensation claim could have a big financial impact on somebody who's operating a small business. And while I'm sympathetic to that, I'm not sympathetic certainly to retaliatory action taken against somebody. You have a right in Ohio to file a workers' compensation claim if you are injured in the course and scope of your employment. And if retaliatory action is taken for that, then that may give rise to a civil lawsuit against the person who took that retaliatory action. So we have a specialist here, and that's her main focus is, if you're injured at work, you file a workers' compensation claim, and all of a sudden you're fired because of that, that could land them in some pretty hot water and give rise to various civil penalties. So that is another thing where there's a lot of very specific and relatively limited time periods that you have to take action if you are terminated as a result of filing a workers' compensation claim. And again, very important there if that happens to contact, a legal professional to talk about your rights in that situation.
Yeah, that's one of the top advantages I like about AG Climber is that you have that automatic cascading support that if it goes into another, you don't have to start over with another firm, or that's probably why you get a lot of referrals from a lot of other law firms.
Yeah, I think you could think of a situation. Let's say we have an individual who drives for their job, and they're in a motor vehicle accident. It's the other person's fault. That's going to give rise potentially to a personal injury claim, which we handle here. It's going to give rise to a workers' compensation claim, which we handle here. And then if we had the unfortunate situation where that person, after filing their claim was terminated, it could give rise to, a retaliation lawsuit again, which we handle here. If that person ends up unfortunately being out of work for 12 or more months, it may give rise to a social security disability claim, which we handle here. If there are issues of short or long-term disability or other sorts of state disability, again, we handle those things here. So it is important, I think, in this industry to kind of be a one-stop shop to help people not only identify all those issues, but to be able to say, you don't need to go elsewhere. We can handle this all internally here.
That makes sense. And going back to your previous response, I was just thinking in my head there, most of the cases have an HR department. They have a legal department. You don't. Most people in that situation have seen these before. You haven't. So the ability to get somebody to get you caught up makes sense with reaching out to you sooner rather than later. And then the retaliatory sort of minority that would retaliate because it hits their bottom line or they take it personal, isn't the structure where it would hit him, but probably in the form of higher rates? Because doesn't he pay into that fund to pay situations like this? Could you unpack that a little bit structurally?
Yeah, absolutely. There are, you have a couple different options as an employer in the state of Ohio. If you meet certain requirements, you have to have workers' compensation coverage. Larger companies may be self-insured, but especially with smaller employers in the state, they're almost always what we would refer to as state fund employers, which means, they pay their workers' compensation premiums. And so if they have an employee who is injured, then it is the Ohio Bureau of Workers' Compensation that pays for their medical care, pays them their off work benefits. So it's not coming, directly out of the pocket of the employer. And as I kind of touched upon already, I speculate that there's some confusion sometimes with small business owners. They think something happens and they think it's going to be a big hit to them financially, but that's why their workers' comp coverage is there. It's there to protect them as well, right? It goes both ways. It's there to protect the injured worker so that they can seek their medical care and get paid for their time off work due to the injury, but it's there to protect the employer too. They pay their premiums, and if somebody gets hurt, then it's the workers' compensation state fund that takes care of that. You are correct. I'm on the injured workers side here, but I know enough to say that yes, in the same way that having, let's say, repeated accidents as a automobile driver could impact your auto insurance rate, you know, being an employer who is consistently, having injuries, large claims, and things like that, it can impact their workers' compensation premiums. But yes, you're correct in that the employer, the boss is not paying out of their pocket for these things. It's coming from a state fund.
Makes sense to go down that one more step about drawing sides because I think it helps illustrate the point of the lay of the land for that person, just maybe deciding to file a claim. Is that so? You're on their side, HR and their attorneys are on the employer side, and you represent this at the commission, what's called the commission level. And so, what you're going against is the workers' comp fund in it. So they have somebody on the bench that's going to be fighting this, asking questions, determining, and again, it's you and the clients. Is that the sort of the I don't want to say battleground, but is that the lay of the land as far as structure?
Yes, generally speaking. So for an Ohio state fund workers' compensation claim, there's going to be essentially three parties to that claim. You have the injured worker, of course, and you have the employer, and then you have the Bureau of Workers' Compensation. So sometimes when we have, somebody who's injured, we'll go to a hearing before the Industrial Commission of Ohio. That's the entity that conducts all of the administrative hearings in a workers' compensation claim in our state. And there could be two people sitting on the other side of the table, across from us, where the injured worker is sitting. That is a representative for the employer protecting their interests, and a representative from the Ohio Bureau of Workers' Compensation protecting their interests. These things can change over time. The older a claim is, it's eventually not going to have any impact on the employer anymore. We call that going out of experience. And when that happens, a lot of times you stop seeing any sort of employer representative on the other side, and you just see a representative from the Bureau of Workers' Compensation. Likewise, with larger employers and self-insured employers, because they are taking, the full kind of financial impact of a workers' compensation claim instead of relying on that state fund, then you don't see the Ohio Bureau of Workers' Compensation rep at the table. You're just sitting across from the employer's rep typically in those cases.
Okay, that makes sense. I also noticed that. So in my mind, I'm thinking that like that's sort of like an arbitrary, or it's going to, it's not a legal system. Its own an arbitration. That's the word I'm looking for. It's sort of like an arbitration phase, and then if that doesn't work out, then it jumps into like the regular legal system at court. Is that? Did you fill that in? It's something that you think you understand until you say it out loud. I'm like, I don't know where that transition happens, but it seems like it's its own little ecosystem until it's not, and then it goes into the regular legal system.
Yeah, so you can think of it as it kind of grows out from a relatively small entity dealing with a case, and it can grow quite large. So even initially in these workers' compensation claims, let's say that a claim is approved and somebody needs a surgery. A doctor will put in what's called a C9 request in the claim to perform a surgical procedure. And in a state fund claim that initially is going to be looked at by multiple different entities before it even gets to the setting of an industrial commission hearing. There are several processes there to see, can we approve this? We being the BWC, can we approve this without the need for hearings and things like that? But whether it's approved or denied, there's appeal rights, right? So if it was approved by the BWC, the employer might appeal. If it's denied by the BWC, then the injured worker and our office on their behalf is going to file an appeal, and then it goes to the Industrial Commission of Ohio that conducts all of these hearings. That's administrative law system essentially. So those decisions are binding. They have legal authority, certainly, but yes, there's a multi-step appeals process there with the Industrial Commission. And ultimately, if you get to the point where they say, hey, it's the end of the road, there's no more appeals here, then at least on certain issues, claim allowance is a big one. Or, let's say your doctor says you have this medical condition and there's disagreement there and that's ultimately denied. We're going to have the ability to appeal that into the actual civil court system. So your county courts of common pleas, we're located here, our main office in central Ohio. So a lot of the times we're working within, Franklin County, for instance, Franklin County courts of common pleas, but we have cases all over the state and the county courts. And then it can go up from there, right? You have the courts of common pleas up to the appellate courts, and then workers' compensation cases sometimes end up at the Ohio Supreme Court if they, contain very important issues of law and things like that. So, it can go from being a very small little issue with a few people involved all the way up to the highest court that we have in the state. Hey, Mark, I can't hear you. Can you hear me?
I'm sorry. Yeah, I was saying that in the world of personal injury, they sort of advertise, no fee until we get money for you and all that, and so that's sort of understood. But in workers' compensation, people might be thinking, can I even afford an attorney? Because it is an arduous process. Seems like a lot of research, a lot of things could go into different phases. So they might be thinking, can I even afford this administrative help? How much does it cost to hire a workers' comp attorney? And what happens if they don't, if they don't win? Is it all contingency, or could you just unpack that a little bit for a person that might be, I make a call, that's good, I get the advice, and then I got a bill in the mail. Is that what happens here too? Like, because everybody else is billing them, the medical, the thing. I mean, is that
Right.
part of the structure?
Right. So that's a very important question. And that's a lot of times one of the initial questions that, potential clients ask us. Because if you think about the situation in which they're coming to us, right? Many of them have been injured and they're not working. So they're not getting a paycheck. And so they're especially concerned with, how do I take on another cost right now? And that's one of the main reasons that, our firm, and essentially any firm who's going to be working in this area of law, is going to work on a contingent fee basis. That is, you don't pay a retainer, you don't pay an hourly rate, right? It is, if we are involved in your case and we are successful in obtaining benefits for you, then we are going to be paid our attorney fee as a percentage of those benefits that come to you. And so I think in that way, that takes care of a lot of people's concerns that they're going to have some massive out of pocket cost, right? Now, there is a potential cost there in that, again, our fee is coming out of some of the benefits that come to them. But I think the important thing to think of is that frequently in these cases, without our involvement, those people aren't going to be successful in getting those benefits, right? So I think it's important to understand that from our perspective, it's a net positive, hopefully to these people. But yeah, that's the general fee structure is going to be that, we're only getting paid if we are successful in getting benefits for you. If we were to take a case on, for instance, and do everything we can to get it approved and it just doesn't happen, it gets denied, then there's no benefits paid there. And so we're not going to get an attorney fee on that. And from our perspective, that's okay, right? I mean, we're not looking at every single case as how can we make money. We're looking at every single case as how can we help this individual? How can we advocate for this individual here? If we're able to obtain benefits and we make a fee, that's great. That's how we keep the lights on. But we understand sometimes that, we're just not going to get there. And in that case, that person's not going to owe us an attorney fee.
That's a relief just to have that confirmed, because I was just in my mind, like, the billable hours are staggering in some of these things. How do you address? You'd said to get to you as early as possible in the process. Do you have resources that would help sort of augment their case? Like, do you have, I mean, back to the Perry Mason at the beginning there, do you have expert witnesses or people to help counter medical? Do you have like a directory of people that you can bring in on your side to help them counterbalance all the support they have on the opposing side?
Yeah, I think what a lot of injured workers don't necessarily understand or even see in their cases, they're hurt at work, they go to urgent care, the emergency department, they follow up with their medical providers, and then all of a sudden their claim is denied and they're saying, well, why? Why did this happen? And, if you go into their claim file, you see, okay, well, here's why it happened. Either the BWC or the employer went out and got, an independent medical exam or a medical review by a doctor, and that doctor is opining that they weren't injured or they didn't sustain the medical condition that's at issue. So, yeah, a big part of what we do when we're involved in a claim, first and foremost, we're going to go to the treating providers. I mean, that's kind of the best we can do if there is an expert on the other side, saying that this person wasn't injured or that they don't have the particular medical condition in question. The best thing we can do is go to the medical providers that are treating our client and have them offer rebuttal comments to that, right? Have them write a report and say why that's wrong or why they disagree. But we do oftentimes get to a point where if that person's not willing or able to, provide that, they're very busy people, right? And like I said, we're working within all these kind of strict deadlines. If that's the case, then oftentimes what we will do is we will retain, an independent medical expert who can, perhaps do an exam, look at all of the records and give us an opinion, right? We're not telling them what opinion to give us. We're going to them, we're presenting everything to them and saying, what's your perspective on this? And if it supports our position, of course, then that's going to strengthen our case going forward. And it's going to offer a chance for there to be a medical opinion that uh, is potentially critical of the employer's medical opinion or the BWC's medical opinion, and can greatly increase our odds of success. So there are definitely doctors and other medical providers who we work with frequently, and we send them these cases and we say, hey, here's all the records, here's the individual, they're happy to talk to you, they're happy to submit to an exam, give us your opinion on this. And that could be very, very helpful and crucially important in these cases to increase our odds of success.
Okay. Finally, just to wrap up, as a person learns about the process and is ready to call for a discovery call, is there something they should have ready in advance, or do you mind just walking through them, giving them the list? Like, how to make that call the most productive out of the gate?
Yeah. So when we have a potential new client call in, frequently the first thing I'm going to say is, what happened? Right. Presumably you're calling in because you were injured at work, but tell me what happened. Tell me how you were injured. But, yes, we're going to ask questions about what medical care did you receive? When did this happen? Did you report this to a supervisor? Were there witnesses to the incident? So, I'm perfectly happy to talk to somebody who doesn't have any of that written down and they're just trying to recall it from memory. But yeah, I think if you want that initial consultation, that initial phone call to be as useful as possible, it is helpful, I think, to have those things written down, have your date of injury written down. If your claim is already in process and you have your workers' compensation claim number, which is going to be uh, two digits. If you're injured in 2025, it's going to be 25 dash and then followed by a 6-digit number. If you have that written down. If there were witnesses, have their names written down. If you reported it to a boss, have their name written down. If you know that you've been to 3 medical visits, have the medical providers or the locations written down. Any of that information that you have there with you is going to help us get a really quick start on the claim. But I want to be clear. I mean, I have a lot of people call me and, they're in a degree of crisis, right? So they may call me and say, I don't have any of that information for you. All I can tell you is I was injured and I need help. And, we're going to be happy to assist those people and, work with them as time goes on to gather all of that information, right? We might have them complete some questionnaires or get us more information when they're at home or they have their records in front of them. So it's not an absolute necessity to have all of that upon the initial consultation, that initial phone call. But certainly if you're able to kind of gather those things, it can help us get a little bit quicker start on the case.
Perfect. That's good.